All right, thank you, Chris, and thanks to ELI for having me here today to go over this. 2 hours is going to seem like a lot of time, but believe it or not, for going over these two very complicated statutes, it's not very much time. So I'm going to give you the broad strokes of each of these laws, talk about the general goals and mechanisms in each of them. And also I'm going to refer occasionally to some background materials that we've made available on the website. These are important because if you do have more questions about some of the more nuanced areas of these laws, you can refer to those. Those mainly consist of some of our own work product for guiding you through the statute, but mostly it's agency guidance documents, which are very helpful and useful in understanding these topics. So this is the first few slides. Here we go. These are the general topics I'm going to be discussing today. And rather than go forward a straight recitation of each of these statutes, I'm going to cover all these topics using a narrative approach. It's basically a story that tells how the statutes work together side by side. Along the way, we'll discuss, through each of our facts, how the statutes are implicated. And then at the end of the presentation, we're going to go through the Elk River Freedom Industries fact pattern that was distributed to everyone. And then I believe all of the ELI faculty has been covering. So before we get into that stuff, ELI asked that I talk about who I am a little bit and what I do and how my practice implicates these laws. I'm an associate at Paul Hastings, as Chris mentioned. I'm in the Environmental and Energy Practice Group. My practice area is divided into two basic areas: regulatory compliance counseling and then transactional work. Between the two, I would say that we spend about probably 2/3 to 3/4 of our time doing transactional work, and then about 1/4 to 1/3 doing regulatory compliance counseling. On the regulatory compliance side, it's things like assisting clients with permitting, going through the motions with securing federal grants of financial assistance. It's navigating remediation of contaminated properties is also a big part of what we do. And we work mostly with pharmaceutical industry and the solid waste industry. With respect to transactional work, it's a lot of corporate mergers, acquisitions, financings. And the process that we go through to do that is what we call risk identification, quantification, and apportionment. What that means is that in a given business transaction, we look to identify environmental risk, and then we work with environmental consultants to quantify the risk. And then once we have an understanding of how much risk there is, we look at the transaction documents and we negotiate ways of apportioning risk between the parties, either lenders and borrowers or buyers, sellers, landlords, tenants, etc. So that is the basic overview of our practice. A little background on me. I went to Vermont Law School. I wanted to ski and snowboard a lot, and somehow I found myself in environmental law, and now I live in Washington, D.C., because you got to eat. So this is an overview of the two statutes. I'm going to start talking about CERCLA. And when I talk about CERCLA, I'm referring to the Comprehensive Environmental Response, Compensation, and Liability Act of 1980. We love acronyms in the environmental law world, and that, I think, is no more true than in the clean lands area. I'm going to be referring to acronyms a lot, and I will do my best to explain what they mean initially. But again, it's something that, regulatory environmental law, it's very jargony, and so hopefully I won't get you lost in that. Superfund is another common nickname for the law. When the law was originally established, it had set up a trust fund to help pay for contamination of, or not pay for the cleanup of contamination at properties, and it was funded through a tax on certain hazardous materials. The Superfund is ostensibly gone dry since then, but the term persists and people refer to it as the Superfund law. In practice, I'm going to use the terms interchangeably. CERCLA is the main federal law that seeks to clean up contaminated property. At its most basic, the statute embodies the polluter pays principle. And that principle is exactly what it sounds like. It makes sure that those who are involved in the management, use, disposal of hazardous substances are, all help pay for cleanup of contaminated properties. CERCLA accomplishes this goal by giving EPA broad powers to investigate and address contaminated sites. It sets a logical, if a bit harsh, regime for allocating liability amongst polluters. And when we refer to polluters, we're going to be talking about potentially responsible parties, or PRPs. Finally, it allows states, EPA, and PRPs to sue each other to recover cleanup costs. The second goal is that basically by promoting this regime of liability and cleanup, we can reintroduce contaminated sites back into the marketplace. Contaminated properties aren't, they're not valuable, and by requiring those responsible for the contamination to clean it up, CERCLA puts those properties back into the marketplace. There's been some regulatory changes over the years that have sought to advance that goal more fully that we'll talk about, and those come into play mainly with some of the defenses to liability. A little bit of background on CERCLA. You'll hear about something called CERA, which is the Superfund Amendments and Reauthorization Act of 1986, I believe. And that was a statutory action by Congress that, revised a lot of CERCLA. One of the most important provisions it added was tools related to settlement and contribution, and we're going to talk about that more later. Another thing that CERA did that we're not going to spend any more time talking about is add something called the Emergency Planning and Community Right to Know Act. That's also referred to as CERA Title III, or EPCRA. It requires people who maintain hazardous substances on their property to maintain logs of where they're located and to notify emergency responders about where they're located and how they plan to address emergencies in those contexts. The idea being that if you are responding to an emergency at a chemical facility and you're a firefighter, you need to know exactly where all the hazards are at the facility. And EPCRA put into place a lot of, forms and filing requirements for PRPs and for other people who use hazardous substances to file notifications with agencies and states so that they know where everything is located. When we speak about CERCLA liability, we're talking about obligations to pay for the costs of addressing releases of hazardous substances at a facility. And each of these terms, releases, hazardous substances, facility, are defined very broadly by the statute. And for the sake of understanding our story that we're going to go through, our fact pattern, basically assume that any building or piece of land is a facility, assume that everything that's considered hazardous under RCRA, or the Resource Conservation Recovery Act, is hazardous under CERCLA, and if you spill, dump, abandon anything, you've released it. The bottom line is that when you've got these three things together, you've got the basic pieces of a CERCLA claim. We'll talk a little bit about this more later, but there are four general types of liable parties. These are the PRPs under Superfund. What we've got are current owners and operators of a contaminated facility. There are past owners and operators who owned or operated contaminated property at the time hazardous substances were disposed on it. There are people who arranged for hazardous waste to be disposed of at a contaminated facility, and transporters who haul hazardous waste to a contaminated facility. All of these classes of individuals are all jointly and severally liable under CERCLA for response costs. And, the hammer in all this is the joint and several strict liability concepts. This is how CERCLA is able to ensnare each of these liable parties into its net of liability. Strict means that the liability is without regard to fault or negligence. Joint and several means that each individual plaintiff can be, the plaintiffs can hold any one PRP among a group liable for the entire cleanup. And then among those PRPs, they're responsible for suing one another in order to recover their costs. But effectively, if you have incurred response costs, you can go and sue any one individual PRP or all of them at the same time. It's entirely up to you. And finally, it's retroactive liability. So the liability extends to actions, to releases of hazardous substances that would have occurred prior to establishment of the statute in 1980. RCRA is the sort of corollary to CERCLA, and it is effectively a groundwater protection statute. And RCRA stands for the Resource Conservation and Recovery Act. It's the regulatory regime for preventing future Superfund sites and for protecting groundwater. The thinking being that if solid and hazardous waste is managed properly in accordance with these rules, we'll avoid future groundwater protection problems. Effectively, we'll avoid future Superfund sites. It's a very prescriptive statute. It is a classic command and control regulatory regime. It imposes very strict and very precise standards on everyone sort of in the chain from hazardous waste generation to hazardous waste transportation to ultimate hazardous waste disposal. It's something that the regulated community hates. RCRA is one of those statutes that is oftentimes held up as a sort of the paragon of EPA regulatory overreach. But this is honestly something that EPA strives to address, and you can see from the the mountains of regulatory guidance documents out there, they do their best to help the regulated industries comply with the statute. Historically, RCRA was one of the last major sort of prescriptive environmental statutes that was passed in this country. And you can think of it this way, that once you've passed the Clean Water Act and you've passed the Clean Air Act, and these statutes require the control of all these pollutants, there's always going to be byproducts. And those byproducts turn out to be hazardous most of the time. And so that stuff is left to RCRA to manage for its ultimate disposal. In terms of what we're going to talk about under RCRA, there are three major programs with shared enforcement between the states and the federal government. Most of what we're going to talk about today is the Subtitle C, the Hazardous Waste Management Regime. This is what we refer to as the cradle-to-grave regime for managing hazardous waste. When I mentioned earlier that generators, transporters, and companies that ultimately dispose, treat, and provide for long-term storage of hazardous waste, those are all regulated under RCRA Subtitle C. The second thing is Subtitle I, and we're not going to spend too much time talking about this, but it is an important aspect of RCRA. It established management standards for underground storage tanks. Underground storage tanks are everywhere. Every time you see a gas station, you're looking at 10,000, 20,000 gallons of petroleum products being stored underground. And so part of RCRA was put in place to require that those underground storage tanks be managed properly. The last subtitle we're going to talk about is D, which is the provisions for non-hazardous waste. Again, we're not going to spend much time talking about this. It is important, though, because Subtitle D sets state-run programs for the management of solid waste within landfills. So it sets minimum technology requirements that states implement to manage solid waste in the ground. It's important because it sets up sort of a base level framework that states follow when they manage solid waste in the ground. So RCRA and CERCLA, a story in three parts. Now that we've done our overview, we're going to tell you about the main characters in our story, and we'll start talking about how RCRA is implicated by that. The people in our story are Walter, Jesse, and Gus. Walter lives in New Mexico, and he owns a boutique chemicals company, White Pharmaceuticals. Our second main character is Jesse. Jesse also lives in New Mexico, and he owns and operates a company that hauls hazardous waste. And last, we have Gus. Gus is just a simple chicken farmer. As with all great stories, our story begins with a 55-gallon drum. In the commercial and industrial sectors, you'd be hard-pressed to go anywhere and not see a 55-gallon drum of materials. It is sort of the standard for bulk chemical storage. And so Walter, as the manager of his White Pharmaceuticals, has this drum, and it is waste, and he has to get rid of it. And so he wants to be conscientious and comply with the law. So the first thing he has to do in order to understand how his waste is going to be managed is determine whether or not he's got solid waste. And in Walter's case, this is easy, but we're going to spend a little bit of time talking about this because it's a very important concept. The reason why it's so important is because this is the gatekeeping concept to RCRA Subtitle C. All the requirements that would otherwise apply to generators, transporters, and those who treat, store, and dispose of hazardous waste come into play when you've got solid waste. But if you don't have a material that's solid waste, you don't have a RCRA problem. Generators all have these various obligations, and these are things that Walter is concerned about. He has to identify his hazardous waste streams. He's required to register himself with the state or EPA. He's got to manifest and document his waste. He's got to worry about on-site storage and management requirements. He's got record-keeping requirements, training, and finally accident release and response requirements. These are all obligations that generators of hazardous waste have to deal with. But if what they're managing isn't under the statute termed a solid waste, then they're not subject to Subtitle C or any of these prescriptive requirements. So, in addition to being foundational, it is unfortunately one of the most convoluted and complicated concepts, I think, in all of the statute, and in fact, maybe all of environmental law. It is a Swiss cheese block of exceptions to exceptions to exceptions. And I'm going to try not to get too lost in the weeds and sort of cover the basic concepts, but it's very important. And the reason why it's so important is because complying with RCRA is expensive, and regulated industries would prefer not to have to do it. And part of the reason, they want to avoid being subject to regulation under RCRA is because they want to recycle their materials. And recycling is something that EPA wants to encourage. But they also don't want recycling to be done in a manner that might damage the environment. So there's a very careful balancing act that the agencies and the regulated industries work through, where they're trying to, figure out the best way to manage these very hazardous secondary byproducts of industrial processes in a way that's cost effective, and that allows for recycling, but then doesn't result in harm to the environment. So what you have to figure out when you're dealing with situations like this is what types of processes involve legitimate recycling, and what types of processes involve the generation of solid waste, which ultimately leads to the application of RCRA Subtitle C. The answer is two concepts, and I've got them here up on the slide. They are use or reuse, which is typically considered not solid waste and thus not subject to RCRA Subtitle C. And then the other concept is reclamation. And reclamation is the types of processes that generally EPA considers to be still subject to Subtitle C. And so just to unpack these concepts a little more. Recycling typically is considered use or reuse, and what that means is using your secondary material just exactly as you've got it coming out of your process. So if you've got a waste material coming out of some process and you immediately take that waste material and you stick it back into another process and you use it as a feedstock in some other process, typically EPA is not going to consider that to be generation of hazardous waste. They're going to say that what you're doing doesn't result in solid waste, and so therefore your process isn't going to be subject to Subtitle C. Now there are some exceptions to this use or reuse, because EPA looks at certain uses or reuses and says, no, that's way too much like managing hazardous waste, or that is extremely dangerous, and so we're not going to allow that to occur outside of the Subtitle C regulatory regime. These are things like use constituting disposal, and this is something like land application of hazardous waste. Certain hazardous byproducts are good for de-icing, or they're good for fertilizing. And so there is ways in which you can do that, and there are ways in which you can't do that. And so EPA has very specific regulations for, what types of processes count as use constituting disposal. There's something called speculative accumulation, which EPA typically considers not to constitute use or reuse. That's where you're basically stockpiling byproduct materials with the sort of speculative intent to someday reuse them. EPA isn't going to allow you to do that because that too closely runs into just storage of hazardous waste, which is subject to very strict requirements under Subtitle C. There's also burning for energy recovery. EPA does not want people to burn materials in order to generate energy because that is, subject to regulation under Subtitle C as hazardous waste incineration. On the other side of this is the reclamation concept. And reclamation simply means extracting a valuable component from secondary material. This is doing things like regenerating spent solvents by extracting material and separating, valuable components from other, waste materials. This, EPA considers this to be too close to treatment of hazardous waste. And so this, while it, has elements that seem like it's recycling, EPA is going to consider this to be a form of solid waste management, and so they're going to require those processes to be subject to Subtitle C. There are a number of ways in which this is all subject to flux. Most importantly, in 2008, the EPA put out a series of rules that basically broadened the category of what constitutes legitimate recycling, and so they broadened the concept of what wasn't subject to Subtitle C. They simply said, in three basic types of rules, that materials that are reclaimed subject to the generator's exclusive control is not going to be subject to Subtitle C. Hazardous secondary materials that are transferred to an unrelated entity for legitimate recycling or reclamation. And then they instituted recycling or reclamation sort of standards that helps generators and managers of this material understand what types of processes aren't going to be subject to Subtitle C regulation. The sham recycling criteria is probably one of the most important. It requires generators to evaluate the toxics within the material. They have to evaluate the value of what they're getting from these materials. And they have to determine whether or not the secondary material actually provides useful contribution to whatever process they're using it for. So fast forward to 2011, and there's now a series of proposed rules that are still pending before the agency, where they're looking to roll back some of these allowances for reclamation. They're looking to impose new treatment standards for reclaiming secondary materials, and they're expanding the category of criteria that apply to what they call sham recycling, which is recycling that isn't otherwise done for a legitimate purpose. Obviously, the important upshot of these rules is that they seek to sort of roll back some of the exemptions that were added in 2008 and impose some greater requirements on them. And the interesting thing about the 2011 proposed rules is that they don't necessarily eliminate some of the exemptions that were created in 2008. They simply impose some additional standards on them. Industry likes to call them Subtitle C light. But the important interplay in all this, and if you've been lost by this, there's a great outline. I say it's great because I put it together. That outlines how the definition of solid waste works, and that's in the materials that we provided online. And the important upshot of all this is the extent to which industrial recycling is going to be promoted and the extent to which it's going to be subject to some kind of regulation to prevent harm to the environment. But again, Walter's case is easy. He knows that the material he's got is going to be discarded. He's abandoning it. He's getting rid of it. He doesn't want anything to do with it. He's not going to try to recycle it. So he needs to go about determining whether or not his waste that he's got is hazardous. And EPA, again, has a very prescriptive set of regulations for determining whether or not waste is hazardous. And there are two categories. There are either listed hazardous waste and there are characteristic hazardous waste. The first is on the left, and listed hazardous wastes are there's a complicated process where EPA conducts a rulemaking, and they put together a list of hazardous waste. And there are roughly 800 listed hazardous wastes, and they fall into a number of different categories. There's the F list, the K list, and the P and U listed waste. And F listed wastes are wastes and sludge from 7 non-industry specific sources that include things like spent solvents and wastewater treatment sludge. These are sort of specifically identified chemical byproducts. And then the K-listed wastes are hazardous wastes identified for specific industries. So when specific industries like wood preservation or petroleum refining or the steel and iron industries produce a certain type of waste, typically they'll find that on the K-listed waste because it refers to industrial processes specifically. And then finally, the P and U listed wastes are discarded commercial chemical products. These are chemical products that haven't been used. They're in their pure form and they're being discarded, or they're in some sort of mixture as the sole active ingredient. The more common way in which hazardous waste ends up being identified as hazardous is by characteristic. On the right-hand side, you see the 4 different symbols for characteristic hazardous waste. This is, instead of specifically looking at how the waste was generated or whether or not it falls on a specific list, this is looking at the chemical characteristics of this specific material and determining whether or not it exhibits characteristics of hazardous waste. The first is ignitability, which is the tendency for the waste to catch fire. Corrosiveness is basically a measure of pH. It's how acidic or basic a given material is. The third is reactivity, which is the tendency for the waste to explode and release toxic gases. And finally, toxicity is the measure of the material and its ability to leach toxins into the environment. So if you've got a material like a solvent or other kind of waste that you spill into the ground, toxicity is basically a measure of how fast that material will leach into the environment and how much damage it'll cause. Toxicity is kind of like it's a catch-all in some senses because it seeks to identify those materials that aren't necessarily immediately sort of hazardous upon its inherent characteristics, but how it reacts with the environment when it's released. And there's a few specific rules that we should talk about in this context, and these are EPA developed regulations. The first is the mixture rule, and they're relatively straightforward. It's simply that solid waste plus a listed waste is going to be a hazardous waste, regardless of the amount of a listed waste. The idea being that you can't dilute out your listed wastes. A solid waste plus a characteristic waste, on the other hand, is a hazardous waste only if the mixture exhibits a characteristic of a hazardous waste. The contained in rule is a rule specifically designed to account for remediation waste. So when you've got a cleanup of contaminated property and you've got soil that has hazardous waste disposed into it, that environmental media that contains the hazardous waste must be managed as hazardous waste. Finally, the derived from rule, which is generally waste that is generated from the treatment of hazardous waste, is itself going to be considered hazardous and has to be managed as such. A good example of that, as I've got on the screen, is incineration ash. So if you are incinerating hazardous waste as your way of treating it for ultimate disposal, whatever ash byproducts you have that result from that themselves are going to be considered hazardous and have to be managed as such. There are also some key exemptions that I want to bring to your attention. And these are just sort of interesting, if only from a policy-making standpoint. The first is drilling fluids, produced waters, and other wastes associated with exploration, development, or production of crude oil or natural gas. These aren't specifically exempted necessarily from the statute. Effectively, what Congress did is they said, EPA, hold off on regulating this stuff for now, do a study of it, and then see if it merits regulation. EPA did do that study, and I've got the sites to that on the screen. And they made a determination effectively that waste materials resulting from oil and gas exploration and drilling and development isn't going to be subject to RCRA. The same approach was taken with fly ash, bottom ash waste, slag waste, waste from emissions treatment from power plants. This is something that is currently subject to a lot of controversy at the agency. EPA is effectively mulling right now, starting in 2010, how to regulate what we call CCR, which is coal combustion residuals, under either Subtitle C or Subtitle D. The upshot being that if it's regulated under Subtitle D, that means it's effectively considered solid waste, and it's subject to rules about, you know, the sort of the minimum technology standards. However, if it's subject to Subtitle C, all of the requirements of generation, transportation, treatment, storage, disposal, all those harsh regulations come into play. The sort of consensus right now seems to be that Subtitle D is the direction that EPA is leading. And you see reference to this even within the rules where, you know, EPA recently issued its proposed rules for regulating power plants under NSPS, under the Clean Air Act. In that, those regulations, EPA kind of tipped its hand a little bit and talked about how they were leaning toward regulating these coal combustion residuals under Subtitle D. So Walter does his testing, and he realizes that he's got a 55-gallon drum of hazardous waste. He's made a determination that that's what he's got. And so he calls Jesse, and he asks him, Jesse, how long is it going to take for you to get this drum of waste off my hand? And Jesse tells him 45 days. And so the question becomes, is under the RCRA Subtitle D generator requirements, can he store that waste material for 45 days? And so in order to determine that, he has to look at how much waste he's generating at any given time to determine which generator classification he falls into. And there are 3 of them. The most significant are the large quantity generators. These are your, you know, your Chevrons, your big heavy industry. These entities generate 1,000 or more kilograms of hazardous waste in a given calendar month, and they're subject to the most stringent regulation. They may store waste on site only for 90 days at most. And there are other specific regulations that come into play if you are a large quantity generator. We're not going to spend a huge amount of time talking about those, but just know that as your waste volumes increase, the amount of requirements that you have to comply with increase as well. Small quantity generators are the medium quantity. These are entities that are generating more than 100 kilograms but less than 1,000 kilograms in a given calendar month. You can store your material for between 180 and 270 days. And then the final category, which is our smallest of small quantity generators, are called conditionally exempt small quantity generators. These are entities that generate less than 100 kilograms per month. It's the most limited regulation of all the categories. They're effectively limited to manifesting and proper disposal selection requirements, and they can store things on site indefinitely. But again, once they have more than 100 kilograms in a given calendar month, then they have to get rid of it. So on-site storage indefinitely is a little bit of a misnomer. The thing to be careful about is that not all states abide by this regime. As I indicated when I went over the overview, you know, states and the EPA have worked out arrangements where certain states have been delegated authority to implement these regulations. A lot of times the states that have taken full delegation of authority, in particular California, have more stringent regulations. So it's important that when we go through all of these regulations, and then when you get into practice, that if you end up in a circumstance where you've got to answer a client's question, you need to look at the state regulations as well. Because oftentimes, and again, California is always the outlier in this instance, there's going to be more stringent regulations on the state side, and you're going to want to confirm that. Another thing to note about the generator classifications is that this is one of the most common violations that regulated industry is subject to. Storing your materials beyond the threshold requirements, either 180 to 70 or 90 days, is an easy way to get you socked with a big fine. Because what EPA says is that if you have stored your materials beyond the required time frame, you are now a facility that stores hazardous waste, and so you're subject to the TSDF rules, or the treatment, storage, and disposal facility rules, because you're storing hazardous waste longer than the time frame allowed for generators, and you are immediately then in violation of all those regulations that apply to what we call TSDF, or treatment, storage, and disposal facilities. So we know that Walter can keep his waste on site for 45 days because he's got a limited quantity of it, and none of the generator classifications make that forbidden. So Walter has to figure out what he needs to do as a generator, and one of the most important things is that he has to get an EPA ID number. All hazardous waste generators must register with the EPA and or state with delegated authority, and the EPA ID is how EPA tracks hazardous waste from cradle to grave. It gives them a specific, their own unique ID number that they'll use, and so that if EPA ever wants to come back and look at, where did this waste come from when they've got a contaminated site, they can tag that waste to an individual generator. He also needs to comply with the rules for storage of hazardous waste. The rules for storing waste are pretty much common sense. Keep the stuff from spilling into the ground. Keep it contained. That sounds simple, but there's a lot of prescriptive rules about that. Chiefly, waste must be stored in only good condition containers, and labeling of them is an absolute must. Another rule is that containers must be made out of materials compatible with their contents. Sometimes a steel drum is not the right material because what you're storing is corrosive and it's going to eat through the containment. Generators also have to have contingency plans in place in the event that there's a release, so they have to have plans, and they must train their employees on how to deal with a leak or a spill or something like that. Container storage is another important component. The two chief rules about containers are centralized storage, meaning that all your hazardous waste in your facility must be kept in one designated location. The idea here being is that it's going to be easy to lose track of different hazardous waste streams if you're storing them all throughout your facility. The flip side of this is called the satellite accumulation rule. It allows up to 55-gallon drums of a given hazardous waste to be stored at the point of generation. And once you get 55 gallons filled up, you then move that drum or that 55-gallon container to your centralized storage area. Tanks is another way in which container materials are stored, and I've got some examples up on the screen. The important thing to know about tanks and our fact pattern is our Elk River fact pattern that we'll talk about later sort of provides a good example of this. You need to have some kind of way in which collection of this material can take place if the interior containment ruptures. And the most common, we call this secondary containment. And secondary containment is one of the most common requirements for hazmat storage, in solid waste, hazardous waste, anything really. The idea being that if you've got, containment, some sort of extra layer, if the initial material that you're storing your hazardous waste in ruptures, you've got something else on the outside to keep it in. So that there is a spill, the spill is contained within this outside material. And so on the screen you see these drum, these packaging material for drums, so that if there's ever a spill from what's inside either the drums or the tanks, it's kept. And the basic idea is that you have enough containment volume to store all of what you've got contained inside your tank. Another portion of the rules that's really important for Walter to keep mind of is the record-keeping requirements. You've got to keep mountains and mountains of records if you're a generator. All of your manifests, so all the documents establishing when you generate hazardous waste and send it off-site for disposal, you have to keep those. You have to keep all of your waste determinations, any kind of test results, and then something called exception reports, which we'll discuss a little bit in more detail when we get to manifests. You have to keep those. Government inspectors should have access to these anytime there's an inspection. For almost all records, the EPA rules require that you keep the records for 3 years, For large quantity generators, there's something called a biennial report that has to be kept, and those are required every 2 years. And a biennial report is basically a 2-year summary of all the hazardous waste that the large quantity generator has prepared. It's sort of it's their book report, their final exam that they have to prepare if you're a large quantity generator every 2 years. And you keep track of all of it, and you keep a list of where it all went and what happened to it when it got there. And one of the important things that you have to do as a generator is there's a duty on generators to make sure that the transporter that they select is going to be a conscientious operator. That you see your transporter, and if he shows up on a kayak to transport your waste away, EPA is going to impose upon you a duty to raise a red flag. And the last thing we're going to talk about for generators is the manifest. And what you see on screen is a printout example of a hazardous waste manifest. This is from a record-keeping standpoint and from a standpoint of establishing responsibility for hazardous waste cleanup. The manifest is probably the most important component of all this because it provides a record of this cradle-to-grave waste management regime. At each turn of the process, the manifest comes into play. The initial generator is responsible for identifying what his waste is and how much of it is there, and then signing off on it. And then the next party in the process, the transporter, then takes that and says, yep, this is what I've got. And then he delivers it to his location and he signs off on it. And then finally, the TSDF, the ultimate disposal location, that individual is going to be required to verify it as well and say, yep, all this stuff is here and it's exactly as the generator and the transporter represented it to be, and they sign off on it. So once the receiving facility gets this, the receiving facility is responsible for taking a signed copy that has all the signatures on it from everyone before him and returning it to the generator. So that the designated facility sort of completes the loop, and everyone as part of the process understands that everything is worked effectively as it's supposed to be. And then, we referenced exception reports a few slides ago, and this is the process that we're talking about. If a generator does not receive a final copy of the disposal facility manifest, the generator must file a report with EPA or the state. The purpose of that is pretty straightforward. If you don't receive the final copy back, you know that something's gone wrong. And so by virtue of alerting the authorities in this circumstance, you're letting them know that there's some hazardous waste that's gone missing and it might be disposed of improperly or illegally. And so that's effectively how the manifests work. Manifests also form the basis of most EPA investigations at Superfund sites. So when you've got a cleanup at a big hazardous waste disposal facility, EPA can look at all the manifests and they can say, this is all the people that sent waste to this facility. And so if you remember at the overview of the CERCLA portion of things when we talked about liability, there was the category of entities where they arranged for the disposal of hazardous substances. So all those people that arranged for disposal at a given waste site that's subject to cleanup, there's a record then of all the waste that went there. And so EPA starts sending out letters to all these people and says, you guys are responsible, we're doing a cleanup, just to let you know, get together and figure out how you're going to pay for this. And so the manifest is an extremely important part of how all that works. And as a junior associate in looking at these types of things, I've been presented with boxes full of manifests, and it's like, associate, figure out how to where does our client fit in all this, and that's how you establish it. Did you have a question?
I did. I just had a question. EPA recently has a program where you can submit your manifest electronically.
Yeah, that's right. E-manifest.
Is the 3 year still stands, or
So.
required that you submit your manifest electronically? She was talking about the boxes.
Yeah, right. The question was this is for the virtue of the people on the phone. The question was how e-manifesting works and whether or not that is required now. And it's not necessarily required, but I think it will be eventually. The EPA is looking at moving toward making this process more efficient, and the regulated industry doesn't want to have to maintain all this paper, and EPA doesn't want to have to deal with all of this paper. It'd be much easier if they had electronic records they could use. And, the manifest is also simpler in an electronic form because you fill out boxes and check boxes on screen with a mouse or a tablet, and they love this stuff, both the agency and the regulated industry. The problem is that not everybody is as sophisticated as the Chevrons and the Johnson & Johnsons and the Procter & Gamble's of the world, and so it's not yet required that they do it, but I think that's probably the direction that the EPA will eventually move in, but don't take my word for that. It'll probably take years and years and years before it to become actually required. But no, that's a good question, because the e-manifesting is now sort of it's a really hot topic in the RCRA world. Oh man, that's kind of sad. But anyway, so as Walter watches Jesse take his hazardous waste and he gives him a salute, he daydreams about, because Walter's he's really interested in the chemical treatment process of this. He's a scientist at heart, and so he daydreams about all the interesting processes and engineered methods that TSDF's companies are going to go through to manage his waste. And so the TSDF, or the Treatment, Storage, and Disposal Facility, is these are the sort of what I've got on the screen are the general TSDF regulatory components. The most significant of this is that rather than registering, entities that are responsible for permanent treatment, storage, and disposal have to get permits. And the TSDF permitting rules have been around for a long time, and they require that all of the procedures and mechanisms for waste management that this company is going to be using be established in the permit, and that the agency, either the delegated state agency or the EPA, is going to sign off on all that. The concept of a waste management unit is going to be specifically laid out in the permit. And so all of the mechanisms that are part of the long-term treatment, storage, and disposal are going to be called waste management units, and they're going to have specific provisions in the permit governing how those operate. And in terms of sort of the prescriptive substantive standards for how that material is managed, there are two two sides of the same coin concepts. One is the land disposal restrictions, and then the minimum technology requirements. Land disposal restrictions say that, or it's also been referred to as the land ban. It means that hazardous materials cannot be stored in the ground, meaning in a surface impoundment or a landfill or some kind of earthen containment unit, until they've been treated so as to reduce the toxicity to a sufficient point that that earthen containment unit is going to be appropriate for the long-term storage of that material. And long-term storage meaning it's going to contain it in place. And then finally, the minimum technology requirements are the standards that come into play that say once you've applied the land disposal restrictions and you've treated this material down to a sufficient level of toxicity, the minimum technology requirements impose standards for the actual unit itself. So what we're talking about is surface impoundments, landfills, any kind of in-earth containment unit. And what we've got here is a surface impoundment, but this diagram would apply with equal force and effect if we were looking at a landfill. And there's a lot of waves on this surface impoundment, so anyway, don't worry about it. It's just funny that they use this. This is an EPA diagram, and they put all these waves in it as if that would actually happen at one of these. Anyway, so the important components of this are laid out in the diagram. The first is the double liner. The double liner is keeping the waste in place and prevents leaching or leaks, because you've got one layer and then you've got an extra layer. Think of this as applying the secondary containment principle, but for land disposal units. The second thing you need to have is leachate collection, because invariably, even with the most secure of synthetic polyethylene liners, you're going to get rainwater and other kind of material that will leak through, and so you need collection systems in between the liners that's going to collect leachate, as they call it, and then pipe that stuff somewhere else and then treat it and dispose of it. But if you remember from our derived from rule, is that leachate in this context is itself going to be a hazardous waste, and it's going to have to be regulated and managed as hazardous waste. There's been some really interesting reporting that The Guardian has done in the last few years where they track hazardous waste from a contaminated site in Mountain View, California, and track its constituents all across the country. And it's kind of this shell game where all the different hazardous constituents are shipped around and managed, because each step along the way, EPA requires that the TSDF rules come into play. The last layer of regulation, or the minimum technology requirements that are significant that we're going to highlight, are the groundwater monitoring wells. This is the last line of defense, so that if there is eventually some sort of containment breach in these circumstances, groundwater monitoring wells are going to be tripped off, and the operator of the facility and the regulating agency is going to know that there's been a release, and they're going to impose cleanup requirements on that facility. The groundwater monitoring wells, there's going to be requirements in the TSDF permit that say sample your groundwater monitoring wells monthly, quarterly, whatever. These are going to be located down gradient, meaning basically downhill, or if you look at the slope and the direction of groundwater flow, that's where most of your groundwater wells are going to be located. The idea being that if material is ever released, it will go into the groundwater, and that these wells will signal that there's been a release and that a cleanup needs to be implemented. I'm going to go back because there's a couple other things we need to talk about for TSDFs. The last two important components are the closure planning and financial assurance mechanisms. These are like the LDRs and the MTRs, see, acronyms everywhere. Closure planning and financial assurance act in tandem. This is a plan that is put in place in the TSDF permit. It's appended to it, and it's what do we do when we've all gone home like forever, like when this facility is reached its maximum containment, when we're no longer treating waste and this is all cleaned up and gone away. There needs to be a plan in place for what we're going to do. And closure care involves both closure processes and post-closure. And closure is, shutting the facility down, doing the initial cleanup. Post-closure is things like long-term groundwater monitoring that's going to be required in order to determine, if there is residual contamination as a result of the operation of this TSDF for 30 years. They're going to want to know that that material, that residual contamination, is contained in place and that it's going to be cleaned up. And that's what we call post-closure care, is assuring that the long-term effects of this TSDF's operation isn't going to significantly adversely affect the environment and public health. And the last thing, is how are we going to pay for all this? Well, EPA and the delegated states require that these TSDF operators put up some sort of financial assurance mechanism. And if you have any kind of experience with business or financing or whatever, this will make sense to you. When I first heard this, I didn't know what any of it meant, so don't worry if you're lost by this. But things like insurance, surety bonds, letters of credit, corporate guarantees, different financial mechanisms that say that no matter what happens to our business financially, if we go totally bankrupt and belly up, if at the end of our useful life of this facility we are just dead broke, there's going to be some fund somewhere, and it's not like they've got just like a stockpile of cash somewhere. It's like a worst case scenario kind of thing. That's why they're surety bonds or their insurance mechanisms. So the operator of the facility is going to be paying premiums every month, or they've got some other guarantee in place to make sure that when this is all done, there's money in place that can fund closure of the facility and long-term post-closure care. That's really all you need to do. The specific mechanisms and how the financing all works aren't really important. The idea is that the facility is going to get shut down and cleaned up, and that there's going to be money in place to deal with that. Okay, so in terms of specific ways in which hazardous waste is managed, I don't want to go into a whole lot of detail because we could spend an entire seminar talking about hazardous waste incineration and all the different rules that come into play with that. But one of the mechanisms I wanted to highlight is UIC wells, or underground injection control wells. It's worthy of highlighting because it's so it's so significant. It represents a huge portion of hazardous waste management in this country. Roughly half, 49.7% of all hazardous waste is managed in UIC wells. And UIC wells are exactly what it looks like on the screen. It is a very, 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 very deep hole in the ground where hazardous waste is injected. They are regulated under RCRA, but they are chiefly regulated under the Safe Drinking Water Act. And the Safe Drinking Water Act imposes a standard that applies in all cases. And this is a reasonable degree of certainty that there will be no migration of hazardous constituents from the disposal unit or injection zone for as long as the wastes remain hazardous. So let me unpack that legal jargon. As long as that stuff is in the ground, as long as that stuff is within this geologic unit, deep, deep, deep in the ground, as long as it remains hazardous, it has got to stay there. And you've got to know, you've got to be as certain as you reasonably can be based upon all the geologic data that you have at your disposal that this area is going to stay in place, that there's not going to be seismic shifts, that there's not going to be activity underground nearby that's going to interfere with the long-term containment of these materials. And there are periods of time that, over which hazardous materials will just, they will no longer become hazardous by virtue of the volatility of the chemicals or other kinds of chemical processes that just occur by the passage of time. And that is the period of time. That's your time horizon that you've got to look at. And so EPA and delegated states, when they permit these wells for the long-term storage of hazardous waste, that's what they look at. And when they can reach that reasonable degree of certainty that all the stuff is going to stay in place for this time horizon, they'll permit the well, and it can be used for long-term disposal. So Walter, as part of his daydream, he's comforted by the fact that RCRA has these comprehensive corrective action provisions and a very strict enforcement regime. And I won't go into huge details on these. The corrective action program is a TSDF specific cleanup program. It's separate and apart from the Superfund and CERCLA and all the stuff that we're about to get into, because it is specifically geared for the long-term continued operation of TSDF facilities. And so EPA has something called its deferral policy, and I believe we've included that in the background materials, where if you've got a TSDF site that's not abandoned, if it's continuing to be operated legitimately and they've had a release, or they've got a groundwater monitoring well that's tripped off and they need to clean it up, EPA will not enforce them, institute enforcement action against them under CERCLA. They'll use the TSDF corrective action provisions. We'll spend more time talking about how that works under CERCLA, but it's important to know that in terms of practice and how it plays out, the cleanup procedures are largely the same as Superfund. It's just that they're kept within the RCRA playground so that the operator's TSDF permit contains provisions going forward that say this is how you're going to run your facility and this is how you're going to clean up this release that's happened. The idea is that we want these facilities to continue operating because they do serve public good. They do help keep hazardous waste out of the environment. So they're going to allow them to continue to operate but they're going to have to, while they do that, they're going to have to contain hazardous constituents in the environment and clean it up gradually over time as the facility operates. How it's imposed is also something important to talk about. I mentioned permit conditions, but there's also, EPA also has the authority under RCRA to impose orders on TSDF operators. And they can also, they have something called imminent and substantial endangerment authority, where they can require anyone who's managing hazardous waste and solid waste, and that's the important thing to realize about the imminent and substantial endangerment authority, is that any management of solid waste, not just the hazardous stuff, but any kind of solid waste, you can be subject to a corrective action order. The second component is enforcement. EPA has a lot of information gathering power. Effectively, EPA can get any sort of information it wants to about the business operation of a TSDF. And if they want the TSDF to, to conduct a study, to sample the ground, or give them any kind of data they want, EPA can ask for it and get it. EPA also has enforcement powers. They can issue compliance orders, assess civil penalties, suspend permits. Any of that stuff comes into play when TSDF operators violate the terms of their permits. They have authority to refer matters to the Department of Justice, who can bring civil actions to, impose enforcement. The last thing to talk about with enforcement regime is that there is a citizen enforcement provision under RCRA. That's very important. There's been some very significant environmental cleanups that have come about by virtue of the citizen enforcement power. The Honeywell contamination of the Hackensack River in New York is one that was a long-term case brought about by citizen enforcement power. Because just like the imminent and substantial endangerment authority I mentioned a moment ago, with regard to EPA and their ability to impose cleanup orders, citizens have the ability to, anytime they identify imminent and substantial endangerment involving, again, solid waste management, not just hazardous waste, but any solid waste management that results in an imminent and substantial endangerment, citizens and citizen groups can sue under these provisions and bring about injunctive relief. Injunctive relief means that they can get a court to issue an order for someone to fix something. They can't recover damages or costs, but they can require somebody to clean something up or to stop some activity that's causing an imminent and substantial endangerment. Citizens can also bring suits to compel compliance with the act. So if someone's violating the terms of their permit, and citizens groups have the authority under RCRA to bring their own suits to compel compliance with those provisions. So Walter's having his daydream about all this great stuff about RCRA and how well it's going to manage his hazardous waste. Jesse, however, has a different idea. He wants to save a little money. And you would not believe the degree to which this still happens. Where, you've got a transporter of hazardous waste who says to a generator, yeah, I'll take your waste and I'll deal with it, no problem. And then that doesn't end up happening. So he looks for a place to get rid of this drum and some of the others that he's collected. So first he tries a solid waste dump, a landfill for municipal solid waste. And, this is where we can talk a little bit about subtitle D. But again, I don't want to go into huge detail about it. A solid waste landfill, also referred to as a sanitary landfill, is what you see on the screen, or the diagram is the modern sanitary landfill. These containment components that you see are very similar to the RCRA containment requirements for, the minimum technology requirements for TSDFs. You've got components for groundwater monitoring, extra liners, leachate collection. Landfills also oftentimes have gas control systems where they collect methane that results from the long-term decomposition of solid waste in an anaerobic environment. And that gas is collected, and then they either flare it or they sell it. Those requirements come from the Clean Air Act, though, not RCRA. And so again, this all comes from RCRA Subtitle D, where Congress had EPA set forth minimum technology requirements, and then the states have been responsible for implementing those standards over the years. Next, he's driving around for a long time, and he runs out of gas, so he stops at a gas station, not to dispose of the waste, but just to, fill up and grab a soda. So Subtitle I comes into play anytime you see a gas station. Underground storage tanks are being regulated in these instances. Anytime you see a gas station anywhere, you're looking at, like I said, 10,000, 20,000, 30,000 gallons of underground storage. And the federal, EPA sets technology standards for how these tanks are going to be operated. And again, similar to the types of rules we have for TSDFs and for solid waste facilities under Subtitle D, owners and operators of underground storage tanks have to have closure plans. They have to have financial assurance. They have to have they have to comply with requirements that are going to assure containment of that waste, gasoline, diesel fuel, any kind of petroleum products, or really any hazardous substance for that matter. But again, these are requirements only for underground storage tanks. So anything above ground isn't subject to regulation, which is important for our Elk River fact pattern. And the types of technology requirements they impose on underground storage tanks, and they're very technical. But again, the idea is to prevent releases and to monitor the tanks so that if a release does occur, the operator knows about it. And there's also, things that control small spills, technologies that gas stations now have so that, there's an automatic shutoff valve anytime somebody's operating something. Those are when you're filling up your gas tank and it, clicks off when you fill up. Those are requirements that result largely from the Resource Conservation and Recovery Act, because those spills that would result if you overfill your gas tank, it might not seem like much at the time, and you're more concerned about the fact that you smell like gasoline for a week, but those types of spills over time make big problems. And so EPA has rules about automatic shutoff and vapor control and things like that. So Jesse drives around, and this is kind of when we're going to turn the page on our story and begin to talk about CERCLA. So he remembers that he's got an old friend who owns a big chunk of land out in the desert, and he asks him if can I come on your property and get rid of these drums? And the farmer says, sure, what do I care? Just go into the back 40 and drop off the drums. Again, this is something that happens very frequently in practice. You come across fact patterns just like this. And the farmer happily lets him drop it off. And then after a few months later, the farmer that Jesse knew sells the farm to Gus. And so Gus is now our chicken farmer who owns this facility. And Gus doesn't know anything about these drums. He just, took ownership of the property and runs his chicken farming business. But these drums are there, and as the years go by, the drum gets friends, and the collection of them builds and builds and builds. And so it's got this big abandoned area where drums have just been allowed to remain, and over time they've corroded and they've leaked. So, not knowing what to do, Gus calls the EPA, which begins an investigation. And so, yeah, if only they looked like that. I've got a neighbor who works at the EPA, and he's much less assuming than Dean Schrader, though he probably thinks he's tougher than he's like that. But so anyway, CERCLA Section 104 is where we can begin talking about the Comprehensive Environmental Response, Compensation, and Liability Act. Let's unpack the acronym a bit more. It's Comprehensive Environmental Response, Compensation, and Liability Act. So the first component of that is environmental response. So what we're talking about now are the cleanup and investigation provisions under the statute. And so Section 104 grants EPA very broad powers to investigate releases or suspected releases of hazardous substances, but also any other substance deemed a pollutant or contaminant. This latter, pollutant or contaminant, is a far broader category of substances, and it's defined by reference to harm to human health or the environment. The term hazardous substances, on the other hand, is defined by reference to several very broad but still discrete lists of substances regulated by federal environmental laws, including the Clean Water Act, Clean Air Act, the Toxic Substances Control Act, and RCRA, the hazardous waste regulatory regime. So to unpack that a little bit more, pollutant or contaminant is a very broad category of substances, and it just means anything that's going to harm the environment or public health. Hazardous substance, on the other hand, while it is a very broad term that includes practically every substance that is designated as hazardous under federal law, is still limited to several very discrete lists. And I highlight this for you because the use of the term pollutant or contaminant is limited to Section 104. The other provisions that we're going to talk about that govern EPA's response authorities and its enforcement and the liability provisions use the term hazardous substance. So make sure you have that in your mind as we discuss these things. So the standard for when EPA's its investigation and cleanup authority comes into play is very broad. EPA can use its Section 104 authority whenever either any hazardous substance is released, or there's a substantial threat of a hazardous substance release, or there's a release or substantial threat of release of any pollutant or contaminant which may present an imminent and substantial endangerment to the public health or welfare. This is another concept, the imminent and substantial endangerment, that is shared with RCRA in the enforcement and citizen suit provisions. This includes performing on-site sampling of contaminated media and sending out information requests. Basically, EPA has the ability to come onto these properties and issue the property owner an order saying, we're coming here to investigate, we're going to be doing sampling, we're going to be doing investigations, please watch out for our excavators. EPA also issues something called Section 104 order, or Section 104 letters, where they send out an information request to regulated entities. And again, this is if you've disposed of hazardous waste at a facility, EPA is going to send you a 104 letter, and it's going to say, tell me how much waste you sent there, tell us when you sent it, tell us what it was, so on and so forth. Sort of as another flip side to this, EPA's investigation authority is supplemented by strict rules that come from Section 103 of CERCLA, which relate to hazardous substance release reporting. This creates an affirmative duty for anyone who's managing hazardous substances to report anytime there's a release. The important component of these rules is that they only apply, again, to hazardous substances, and there is a very specific list of what we call reportable quantities, or RQs, that come into play. So a minor spill of a given hazardous substance won't trigger reporting requirements. However, larger or more moderate size spills will. And these RQs, as they're called, are listed in the CFR. So now that EPA has done its investigation, it determines that Gus's farm has been heavily contaminated and that a cleanup is required. So under, again, Section 104, EPA has the authority to undertake a cleanup of the hazardous waste or hazardous substance disposal or release site. And again, Section 104, so it's not just hazardous substances, it's also pollutants or contaminants who have been released into the ground. There's a fully regulated cleanup process for Superfund sites and any other properties where EPA has elected to use its cleanup authority. But there's some overall issues we should discuss. The first is that EPA has what's called an enforcement first policy, and this is something we've provided in the background materials. And that basically means that by virtue of, EPA's ability to regulate its own actions, they have implemented a policy that says that they're going to have the PRPs, meaning the people who are owners, operators of these facilities, arrangers for disposal, any of those 4 categories of people, they're going to ask them and try to compel them to conduct the investigation and remediation themselves before EPA will directly get into the mix and use its 104 authority. This obviously didn't come into play with our fact pattern, though in most real circumstances it would. And again, the second important thing here is that EPA and the states, as with what we've seen under RCRA, cooperate to implement cleanups. And again, state cleanup authority and the types of substances and the types of releases that will trigger cleanup authority by the states is often broader than what you see under federal law. There are a variety of types of cleanups, and I'm just going to summarize these kind of briefly. They don't really come into play for our fact pattern. There are removal actions, and then there are remedial actions. Removal actions are short-term cleanups designed to quickly respond and address a release of hazardous substances. So if you've got to get on the site quickly and contain the material, that's going to be a removal action. But if you've got to deal with the long-term consequences, if you're dealing with a permanent remedy for the facility, those are going to be called remedial actions. Think of it like this. Removal actions are what's needed to just contain and stop the release from migrating through the environment. Remedial actions are, broadly speaking, what is done to implement long-term treatment and, reintroduce this site back into productive use. In practice, because I can see some people kind of like, yeah, that seems kind of gray. It is gray. Believe me, it's a very gray. And so don't worry. There's a lot of overlap, and there are volumes of judicial decisions on the federal level determining when certain actions are removal actions and when they are remedial actions. I've worked on a site for a number of years where this has come into play. And it comes into play all the time when you look at the statute of limitations for how long out you can bring a claim to recover your costs, and they're different depending upon whether or not you incurred costs pursuant to a removal action or a remedial action. Despite the gray area in them, the sort of overlying concept is what we call the National Contingency Plan, or the NCP, and that's basically a set of rules for responding to and implementing long-term cleanup. And that's important because when you get into cost recovery, costs can be recovered only to the extent that they were incurred, as the statute says, consistent with the NCP, meaning that you have to do your cleanup properly if you're going to turn around and sue other people in order to get your money back. The last thing is called the National Priorities List, or the NPL. These are the worst of the worst. These are what we think of when we think of things designated specifically as Superfund sites. These are properties where they're the worst of the worst, and the EPA has a specific set of rules for designating how a piece of property, a facility, ends up on the NPL. These are facilities where EPA has primary authority to clean up the site and to deal with it. These are oftentimes sites that have been abandoned, where no one else has stepped up to clean them up, and they've been allowed to fester for a number of years, and so they have become exceedingly dirty, and so they require special treatment, and so that's what the NPL list is for. The last thing to discuss when it comes to cleanups is the question of how clean is clean. Cleanup standards are how we understand that. It's a generic term for a goal, a concentration of a contaminant that must be reached before the cleanup is complete. Cleanup standards are at their base level set by the EPA, but most often states have established their own set of cleanup standards that apply for cleanups taking place within their jurisdiction. And these are what we refer to as risk-based standards. And risk-based standards have become the norm for cleanups of the environment. And what a risk-based standard is for cleanup, for determining how clean is clean in a given situation, is based on the use of the facility. And what this means is that if you've got a playground or a neighborhood or a preschool, the cleanup of that property is going to have to be done to the cleanest possible standard. Whereas if you've got an industrial property, if you've got a refinery, if you've got a chemical plant, those facilities, if there's been a release there, they need to be cleaned up to industrial standards. Industrial standards are effectively going to allow for residual contamination of some quantity to remain in place, but the determination is made that because this facility is used for industrial activity anyway, and because it's very unlikely that sensitive populations are going to have access to the ground or the groundwater underneath this industrial facility, we're going to allow that residual contamination to remain in place. What they're going to also require in those circumstances as sort of a backstop to industrial cleanup standards is something called institutional controls. These are things like deed restrictions or municipal requirements that say that groundwater in this area cannot be touched. It must be left in place. That soils in certain parts of this area must be left in place and they can't be touched. And that if you're going to dig at this facility, you're going to have to comply with certain site management requirements, and you're going to have to put everything back where it was before. But again, because of the low risk to public health from these industrial sites, they're going to allow residual contamination to remain in place. And that's the most important thing to remember from all this. So the next thing we're going to talk about is now that I've bored you to near death probably discussing the comprehensive environmental response issues, we're going to turn now to discuss liability and cost recovery. CERCLA provides rights of action for cost recovery whenever the public or a private citizen has incurred costs in order to respond to real property contamination to the extent such contamination involves CERCLA-defined hazardous substances. So it's basically after you've gone through all the cleanup process and you're either a private individual or you're a state or you're the EPA, how do you go get your money back? And so what we've got on the screen again is the PRPs, the potentially responsible parties, that I discussed a little bit earlier. So I'm going to give some more detail on these. Current owners or operators are just what they are described as in the statute. So Gustavo, our chicken farmer, he is the current owner or operator. He has nothing to do with that drums being dumped on his facility. Sure, he probably should have known about it, but he's a chicken farmer and he doesn't go back there, and it's not his fault. It doesn't matter under CERCLA. He's the current owner, he's the current operator of that facility. Therefore, he is subject to strict joint and several liability for the entire costs of cleanup. It also applies to former owners and operators. The important thing to remember here with this provision is that this only places liability on those who owned or operated at the time of disposal of hazardous substances. So the guy who owned the facility prior to Gus and sold it to him, he'd be, in this instance, considered the former owner because he owned it at the time when all these drums were placed on the facility. And it's not when the material, the statute is, I don't know if you want to call it sloppy, but it's interesting in this regard because it doesn't use the term owner at the time of release. It says owner at the time of disposal. And because the statutory terms are not interchangeable, you've got to look at the conduct that took place at that time to determine if it meets the definition of disposal. Most of the time, the definitions, oftentimes courts will look to the definition under RCRA, under the Resource Conservation and Recovery Act, and there are many similar terms like discharge, deposit, injection, dumping, spilling, leaking, placing into the land or water. Those still come into play. There are sort of, and within that you can see how there can be key defenses. So if you're someone who owned facility in the interim, say there was an owner in between Gus and the original owner who owned it at the time of disposal, they might not necessarily be considered a former owner-operator because they weren't disposing of hazardous substances. There have been court decisions, though, that have said that, and these are largely minority rules, but they have come up with standards that say that hazardous waste that sort of migrates through the subsurface during interim ownership can be considered a form of disposal, especially when you might have known about it and didn't do anything to stop it. But very much in the weeds. For the purposes of our fact pattern, think of the former owner, the guy who owned it at the time when the drums were dumped on the facility. The same thing for transporters. People who either accept for transportation and arrange for transportation, they are considered liable parties. There's a wrinkle with this. These entities must have affirmatively accepted the obligation of hauling the hazardous substance or waste, but they must have played some role in selecting the destination for the materials. So if it's just somebody who accepts waste and you've ordered them to take it from point A to point B, they may not necessarily be considered a liable party. Jesse, however, in this circumstance, is very much a liable party because he absolutely selected the site for disposal. In fact, he took it upon himself to save a bunch of money by dumping the stuff on Gus's farm. Those who arrange for the disposal or treatment of hazardous substances, that is obviously, it's going to be Walter. Even though he wanted this to be done right and he did everything he thought that was appropriate in that circumstance to make sure that his waste ended up at a TSDF, it didn't, and he's still considered a liable party. Recent Supreme Court cases have clarified that for arranger liability to hold, the PRP must have intended that at least a portion of the material subject to the commercial transaction in question end up being disposed. What this means is that there has to be an intention for disposal. That whoever is arranging for someone to take hazardous substances off their hand must at least in their mind somewhere realize that disposal would result. This doesn't come into play in Walter's case, but there are some interesting issues that come into play with companies that sort of send off hazardous materials to get rid of them. Think of recyclers, people who know that hazardous waste might get disposed of, but they're selling the material. They're selling it for some nominal price. Arranger liability has come into play for these individuals as well, even though they're not necessarily, quote, arranging for disposal. So it's just something to keep in mind when you think of liability. So what can be recovered? These are the various categories of costs. It's not all your damages. It is specifically your response costs. The statute defines it as all necessary response costs for actions undertaken by the U.S. government or any other person consistent with a national contingency plan. There's also provisions for natural resource damages, and again, we could spend an entire seminar talking about NRD claims, but we won't. The costs of any health assessment carried out pursuant to CERCLA's guidelines for these. So if you need to do a health assessment for a population that is drinking, potentially contaminated water, those costs are recoverable under the Act. So we're going to put all these elements together, and we're going to get sort of, and as lawyers, we love identifying what the essential elements of a claim are, because these give us our constituent parts for figuring out whether or not we have a cause of action. And so we're going to talk now about the essential elements. And it's basically a series of questions. You've got the contaminated site, you've got the money spent to clean it up, and you've got the persons considered responsible for it under CERCLA. Together, these are effectively your essential elements for a cost recovery suit. Stated in terms that you see most often in statutory text or within cases that implement the CERCLA cost recovery provisions, it is a release of hazardous substances at a facility that results in the incurrence of response costs involving one or more classes of PRPs. And, has there been a release of hazardous substances from a facility involving the PRPs that resolves the incurrence of response costs? I'm kind of beating that to death because it is it's the essential components of when you go after another party under the statute. But the question becomes, who can sue who and when can they do it? You wouldn't think this would be a question given how broadly the statute's written, but it is a very important issue that federal courts have wrestled with for the entirety of the time, the 34 years since CERCLA was enacted. And there's a very long and convoluted history of courts sort of putting down different decisions about who can sue whom under the statute. Because remember, when we talked about the hammer of liability under CERCLA, it's joint, several, strict liability. But what that allows for is that now that Gus, now that Walter, now that Jesse have all been sued by the ETA, and they've all had to give money to the cleanup to fund it, they want to sue each other. They also want to sue the other PRPs, the other people who put drums on that facility. Because remember, over time, those drums gathered friends, meaning it wasn't just Jesse that was using the Gustavo chicken farm for disposal. So these guys know that they're not the ones solely responsible for this contamination. They want to go after other responsible parties. So the question is what provisions of the statute can they use? And there are two statutory provisions in question. One is Section 107A and one is Section 113F. And you can see that that on the one hand, Section 107A was the original provision. And this was the provision that everyone originally thought effectively authorized contribution actions. And when I say contribution actions, I'm referring specifically to the types of cases where somebody who's already been liable or incurred costs to clean up a site goes after other people to get some of their money back. And so any other necessary costs of response incurred by any other person, to most courts' minds, that implied a right of contribution. Congress, when it amended CERCLA with SARA, the Superfund Act Reauthorization, Superfund Amendments Reauthorization Act, I can't even get this stuff straight. They added an express contribution provision, which said, I can't even remember it. Any person may seek contribution from any other person who's liable or potentially liable under Section 107A of this title during or following any civil action under Section 106 or Section 107. The question that arises is where do liable parties fall who haven't yet been sued? And that is what was subject to so much litigation and so much court action over the years. Supreme Court, through a series of decisions in 2004 and 2007, effectively resolved the issue. And how they resolved it is what I've got summarized in the second bullets. And effectively it means that if you've been sued at the outset by a state, EPA, or a non-liable private party, or a PRP who has voluntarily undertaken a cleanup at his facility, then you've been sued under Section 107A. Section 107A is for the public, and it is for purely innocent parties. It is also for potentially liable parties who haven't yet been sued. So what that means is that if Gus, for instance, had voluntarily undertaken the obligation to clean up his property on his own without being sued, without being ordered to by anyone else, he would use Section 107A to proceed against Jesse, against Walter, against any of the other parties that left drums at his facility, against the guy who, sold him the property. However, if you are, like in our fact pattern, where Jesse, Gus, and Walter have all been sued by the EPA, those guys are going to use Section 113. Because Section 113, as Justice Thomas so clearly indicated in his 2004 decision, specifically says that if you've been sued during or following any action or civil action under Section 107, 106, or 107A, it means what it says. There is no implied right of action under Section 107. Section 113 is your sole avenue for relief. The issue becomes very tricky because, as I said earlier, there are different statutes of limitations for these different actions. And so Section 107, even though it has provisions for removal and remedial specific statutes of limitation, Section 113 has its own statute of limitations that say that once you've incurred the cost pursuant to a claim, that's when your statute of limitation runs. Whereas the statute of limitations under Section 107 are all dependent upon the stage of remedial action that you're at. So from a litigation standpoint, it becomes very important to determine where it's appropriate for you to sue and how you've been sued, because that determines your rights of action and your ability to sue other people under the statute. And as I said, Section 113 has some other important provisions, not just the statute of limitations, also provisions about jurisdiction and venue. It's effectively the sort of rules of civil procedure for CERCLA cost recovery. So Gus is obviously very upset about this. He's in his mind, he's an entirely innocent party. He bought this property not knowing about the contamination and not contributing to it in any meaningful way from his perspective. So Congress, in amending the statute over the years, has taken steps to provide for conscientious property owners like Gus. And not necessarily in Gus's circumstance, because what Gus should have done was to hire one of these consulting firms or a local consulting company to investigate his property ahead of time. In those circumstances, if Gus had done that, he'd be eligible for what we call the bona fide prospective purchaser defense. And on the next slide, we have lists of some of the defenses, and I list bona fide prospective purchaser on number 3, but it is the most important for today's purposes. Like for my purposes as a transactional attorney, when I'm counseling clients who are looking at buying assets and their industrial assets, I'm going to counsel them to take advantage of the bona fide prospective purchaser defense. I'm going to tell them to hire a consultant and do what's called a phase 1 environmental site assessment on these properties. And to do that, that gives them the ability to take advantage of this defense. There are other requirements, and we've included what's known as the common elements guidance. And these are common elements that run across these 3 defenses: the innocent landowner, contiguous property owner, and bona fide prospective purchaser defenses. Effectively, they mean that if you're going to be taking advantage of these defenses, you have to be conscientious about the hazardous substances that you discover on your property. It means that you have to allow EPA and responding authorities onto your property whenever they want. You have to cooperate with them, and you have to contain ongoing. If there's a release that you can contain and do something about, you need to take steps to control it. The degree to which that you have to take steps to control those releases is laid out in the common elements guidance, and it's not as onerous as it might otherwise sound. So moving on, Gus has a lender, and they've got mortgages on this property, and they're not sad. They're very happy. Even though Gus has bankrupted himself and isn't able to make mortgage payments on his farm, and his bank has come and foreclosed on it and become the owner, they are immune from liability. Remember, the elements for CERCLA cost recovery include classes of PRPs that are the current owner. And if you're a bank and you've taken ownership of a piece of property because your borrower hasn't kept up on his payments, you're concerned about being liable for the contamination that's on that property because you are now the current owner. Congress has put in place a number of provisions that give these guys liability relief. And what it does is it says that there are actions that lenders can take pre-foreclosure and post-foreclosure to keep them immune from liability. Pre-foreclosure, what the requirements are is this rule called no participation in the management of a facility. This means that as a lender, and this is something that I deal with all the time in practice as in business transactions. As a lender, we counsel our banking and our lending clients to, stay out of the affairs of the facility. Don't get involved in how they're managing things. To the extent that you do, you won't be able to take advantage of this defense. And if you think about it from a liability standpoint, from the concepts of how CERCLA imposes liability on certain PRPs, operators, people who directly operate a facility, end up being subject to liability. And so the no participation in the management rules is kind of is an expression of that concept. It's saying that as long as the lender is taking sort of a hands-off relationship to the borrower and isn't involved in how they're managing their day-to-day affairs and how they're managing their hazardous waste or hazardous substances, the lender is going to be immune from liability, and they're not otherwise going to be considered an operator. Are we? I see people packing up, but no. Okay. Well, the guy with the baseball bat left, so I didn't. I don't know. Anyway, post foreclosure, though, once you become an owner of this facility. I'm sorry, I was totally distracted by the baseball bat guy. Pre foreclosure. One of the other things I need to mention is that you can impose ordinary covenants in your lending agreements that require the borrower to comply with environmental laws, to clean up contamination. The lender itself just can't get involved in that process directly. Post foreclosure, on the other hand, the rules require them to, divest the property as soon as commercially reasonable and be a conscientious property owner, meaning, like with the common elements guidance, if you know about hazardous substance releases on the property, you need to be a good citizen about dealing with those problems. The end. So that concludes the fact pattern, the narrative of CERCLA and RCRA. I would like now if there are any sort of immediate questions before we turn to the fact pattern, I think we can do those quickly. Because I want to do the fact pattern in a way that is discussion oriented. So I will be soliciting your thoughts on the fact pattern. So if you have questions about how CERCLA, RCRA, big picture type questions about how it operates, let's do those now. Yes, left.
What if you inherit land or land is given to you? Are you liable right away when you get the land?
If you the question from the room is, are you liable if you inherited land? Generally speaking, no, you are not. There are specific provisions as to how that works, and I don't know them off the top of my head. I just know that generally speaking, if you receive something through bequest or inheritance, you are exempt from liability. There are other exemptions in place for municipalities who take property through, foreclosure if they have municipal bonds and things like that that are secured with real property. Those municipalities aren't subject to liability. So in addition to lending arrangements and innocent purchases, there are other ways in which people acquire property really through no fault or intent, and that is given some liability relief. So yes, generally, but refer to the statute and cases for how specifically it works. Next question.
So in this situation, knowing Gus realizing he's going to do his due diligence, is there any incentive for him to report to the EPA with what he's discovered, or knowing that he's going to be liable, can you just say, morally, I don't really care, and leave it because he knows he could be sued?
If Gus discovers it, the incentive is the requirements under Section 103, that if he realizes that there's been a release of at least a reportable quantity, and there's going to be some knowledge that's going to be imputed on him in this circumstance. He's seeing a bunch of empty drums. He's going to know that there has at least been a reportable quantity. So while there isn't necessarily a direct incentive, there is regulatory requirements that he report. Also, in these circumstances, nobody nobody, these things don't just get like left. They always get discovered, no matter what. Everybody ends up getting ensnared at some point. The incentive is that the sooner he reports it, the better off he's going to be in the eyes of the EPA, who's going to end up coming after him for cost recovery, and the better off he's going to be in terms of costs, because these costs compound over time. As contamination spreads through the environment, principally through the groundwater, the problems get bigger and bigger and costlier to manage. Groundwater treatment is, probably one of the most expensive ways to deal with contamination, and if it spreads over a larger area, the cost of treatment multiply. So, yes, there are incentives, but they're not direct. No. Yes.
Are there any proposed EPA rules or legal action around the exemption of fracking from RCRA and how to deal with fracking waste?
No. No. EPA has. Oh, sorry. I gotta repeat the question. The question is are there rules that EPA is looking at for waste from oil and gas exploration and production and fracking materials, hydraulic fracturing, the process of injecting chemicals into the ground in order to stimulate oil and gas production from existing or dormant wells? No, there aren't, because EPA, in its mind, has stated all that needs to be said about that in the regulation I cited when I discussed that exemption. Their view is that even with respect to hazardous constituents that might be involved with hydraulic fracturing, that the ways in which those materials are managed and the types of constituents they have in them are effectively managed by state law, and that they're doing rulemaking under other statutes, particularly under the Clean Water Act, to look at how, and again, this is outside of the scope of today's presentation, but when those produced waters come out of a hydraulically fractured well, they've got to be managed by somebody subject to the Clean Water Act, by and large. And so they're looking at pretreatment standards for entities that run water treatment facilities that end up treating those wastes. So rather than evaluate them under RCRA, EPA views either state law being sufficient to handle it, or that their rulemaking and the provisions of the pretreatment regulation under Clean Water Act, that will be sufficient to address hydraulic fracturing. They're also looking at permitting rules under public lands for hydraulic fracturing that goes there, and then additional rules under the Safe Drinking Water Act, because hydraulically fractured wells are typically considered UIC wells of some kind, because you are taking chemicals and you're injecting it into the ground. So the UIC program is going to come into play. So they're looking at regulations there as well. So the short answer is no, but EPA is not, in my mind, ignoring the problem. So let's move on to our fact pattern, because this has some really important teaching elements. On the slide here, I've got what I think are the kind of key components of the fact pattern for the purposes of our discussion. On such and such date, 10,000 gallons of a substance that I'm not even going to try to pronounce, MCHM, and polyglycol ethers leaked from a hole in one of the Freedom Industry storage tanks. The spilled chemicals seeped into the ground and contaminated the groundwater in nearby Elk River. The source was traced to Freedom Industries. DEP arrived to investigate. They discovered a pool of spilled chemicals about 400 square feet outside the leaking storage tank. Chemicals were flowing across the floor of the containment dike in a stream several feet wide and seeping into the ground. No cleanup or containment measures had been undertaken. Workers had noticed the spill, but no one had reported it to DEP or any federal regulatory authorities. So I want to ask some questions about this to see if you guys have been staying awake. These will, I guess, more effectively be answered by those in the room rather than those listening in at home. But in this instance, would RCRA's strict Subtitle C regulations come into play? And if so, how? Think of the predicate concepts for how Subtitle C is applied. and whether or not this MCM, this material that is a useful chemical product sold to coal companies for treating coal prior to it being burned in power plants, if that would be subject to Subtitle C. Do I have to call? Come on, volunteer. Does anybody have a guess? Anybody can guess. I mean, we're all new to this, so it's just.
Would it be yes? It's cradle to grave?
No, it wouldn't. Does anyone know why it wouldn't? Oh, sorry. Someone asked in the room if it would be subject to regulation of Subtitle C because it's cradle to grave. And I will initially say no, but does anyone have a guess as to why it's not? Bingo. The answer, and this is, I wish we could give you a prize. The substances that Freedom Industries had contained on their property was not a solid waste. It was a hazardous substance, sure. It was a toxic substance, sure. But it wasn't hazardous waste because it wasn't a solid waste. Remember, RCRA only comes into play whenever there is material that is being discarded, being abandoned. You're getting rid of this material. Freedom Industries wasn't doing that with MCHM. They were storing it for sale as a useful chemical product. And so all of the prescriptive RCRA requirements that you might think would ideally come into play for the storage of chemicals like this in above ground storage tanks wouldn't come into play. There may be other state rules, other requirements imposing containment obligations on them, but it wouldn't be RCRA because RCRA only applies on the outset when you've got solid waste, and then the determination is made as to whether or not it's hazardous waste. So the question becomes, what about CERCLA? Putting aside the recent bankruptcy of Freedom Industries, could the statute's liability regime be used by the state or EPA to recover response costs against the owners or operators of the Freedom Industries facility? I don't expect anyone to get this question right because it is a trick question. Telling you that it's a trick question, though, might tip my hand. But does anyone have any thoughts about how CERCLA would come into play, either from a regulatory standpoint, controlling how the release is responded to, but then also on a liability standpoint? Okay, well, seeing such enthusiasm for answering the question, does anyone have a guess? Because, I approach this question thinking that absolutely it would, and that CERCLA would provide an ideal avenue for imposing requirements upon the operators of the facility to report the release. And then they would be subject to orders from EPA to clean up the release. And that to the extent that the DEP and CERCLA incurred costs responding, imposing removal actions on the release, that they would be they'd use CERCLA to recover their costs. But believe it or not, there isn't, because the chemicals in question were not designated as hazardous substances under CERCLA. And this was something that I did not realize when I first was presented with this fact pattern, and then when I found this out, I was somewhat astounded. And so, there have been a number of legislative attempts to amend CERCLA or to get EPA to do a rulemaking to increase the number of hazardous substances subject to regulation. The interesting sort of dichotomy you have between the different provisions of CERCLA. On the one hand, you've got the provisions that depend upon the release of hazardous substances. CERCLA Section 103, CERCLA Section 106, and CERCLA Section 107. Again, these are the release reporting. These are your enforcement and your cost recovery liability provisions. All depend on this predicate concept of a hazardous substance having been released. Versus Section, and oh my God, there's a typo up there. That should say Section 104. I laugh only because my initial instinct in this instance was It's on the right. It should say CERCLA section 104.
Instead of 106.
Yeah. Is Chris gonna fix that?
No, I'm not gonna fix it. I'm just gonna do it for-
Yeah, sorry. So for those at home, that is a typo, and that should say section 104. I apologize profusely. And I laugh only because my initial response was to swear loudly, but I have a 3-year-old, and I'm not supposed to swear loudly anymore. So we say, "Oh, monster trucks." That's the expletive he came up with, and I think it's brilliant. So we have a monster truck here. CERCLA section 104 uses the predicate concept hazardous substances, but also pollutants and contaminants. So the interesting thing is that while those obligations to report and the cost recovery provisions wouldn't come into play, EPA would still have the authority in this circumstance to come on site and do an investigation and do a cleanup on the facility because of the use of the term pollutants and contaminants. Right. Yeah. Right. It was released, and people immediately started, feeling the effects of the vapors, and then the impacts to the water were very clear. Imminent and substantial endangerments that would give EPA the authority to respond. So that concludes the questions. Does anyone else have any more questions, either in the room or on the phone? I know we get email questions. No email questions. All right. Yeah, in the room.
I guess just curious then, so if people hadn't started experiencing something and not reported some other way, would they still not have had the authority to do anything about it then? Because
They'd have authority under other statutes. I mean, the Clean Water Act. Sorry, the question was like, what would they do if they don't have authority under CERCLA and RCRA? If there's like no obligations on them to deal with this issue, what comes into play? Well, the good thing is that the Clean Air Act has provisions that come into play whenever there's a catastrophic release of air contaminants, and this, because of the fumes that were released by virtue of this chemical being in the open air, the Clean Air Act came into play. Also, because there was, the predicate for, application of the Clean Water Act is discharge of pollutants to navigable waters, and the pollutants concept is a very broad term that applies pretty much to anything that gets discharged at an industrial facility. So those types of provisions come into play. There's also a number of state laws that were used. One in particular was interesting to me was I think a provision dealing with stormwater management, like controlling their runoff, that gave the state some authority. But West Virginia is an interesting place when it comes to implementing environmental laws. It's the Wild West. Wild and wonderful, as they say. And that holds true with enforcement. So, any other questions about CERCLA, RCRA before we knock off? Yes, in the back.
So, why wasn't it hazardous under CERCLA, but it was hazardous under RCRA? Isn't the definition of hazardous substances the same for both, or?
No, I mean, it wouldn't be considered hazardous under RCRA because it wasn't a solid waste to begin with.
But if it was a solid waste, though, would it still be
If it-
definite, like hazardous, does that encompass the CERCLA?
Sorry, that was a question about the degree to which it would be hazardous under CERCLA or under RCRA if it was solid waste. And yeah, it would be perhaps under a characteristic waste, like toxicity, for instance, would likely come into play. So that would define it as hazardous under RCRA and subject it to regulation. But that would only come into play if it was a solid waste. The corollary to that is that pretty much anything that's, or not pretty much, but anything that's defined as hazardous under RCRA, if it's a listed or characteristic hazardous waste, is going to be considered a hazardous substance under CERCLA. And I think we have one more question. Do we have time for one more question, or? Sure.
It was just, you had mentioned that the chemical, I'm not going to try to pronounce it either, was not a listed chemical under CERCLA.
Uh-huh.
Listed like hazardous substance. So that's why that would have been taken
The question was, is why wasn't that chemical listed? And I think that, yeah, I mean, I'm not sure why it wasn't, to be honest with you. I don't know as much about the history of that specific chemical, and you would need a Toxic Substances Control Act lawyer probably to talk to you about the history of that. The folks at Eastman Chemical probably could tell you something as to why it wasn't subject to regulation, but you know, I'm not sure about that. So that concludes. Thanks, guys. Oh, thank you.